All right. Can you all hear me? Is this mic working? It doesn't seem like it is. Okay. All right. I think we're going to get started for our next panel. Give everybody a moment to get. And we're unmuted for the audience. Okay. All right, so this is our last panel, and then we'll have our closing plenary after this, but we're talking now about the impact of Dobbs beyond abortion, and this panel is moderated by Professor Naomi Kahn. Professor Kahn is the Justice Anthony M. Kennedy Distinguished Professor of Law, the Nancy L. Buck 69 Research Professor in Democracy and Equity, and co-director of the Family Law Center at the University of Virginia School of Law. Before joining UVA 3 years ago, she taught at GW. We still miss her very much. And her first job after college was at an organization that was then called the National Abortion Rights Action League, aka NARAL. She was responsible, among other things, for checking the mail for bombs. So I turn it over to the panel. Thank you.
Thank you. It's really delightful to be here. It's great to be back at GW, and congratulations. What an amazing conference. What Rachel said earlier about bringing all of us together in this way is incredible. Okay, so obviously the title of this panel is The Impact of Dobbs Beyond Abortion. And so we've spent a lot of time already talking about the impact on access to abortion. And earlier today, we've heard about some of the themes of fear and equity and disproportionality and uncertainty. And we've heard about, from Caitlin Myers, the distances that people need to travel. Maya led a discussion yesterday on what we can do to help. Oriaku and Joko discussed the impact on abortion. I won't go through the past 2 days, but we've been talking a great deal about abortion access issues. And we're turning to talk about the broader, additional impact, perhaps not broader because this is pretty broad already, additional impacts of the Dobbs decision, so beyond abortion. And we have 4 amazing panelists. Dr. Kellen Baker is the executive director of the Whitman Walker Institute, the research policy and education arm of Whitman Walker, a community health system here in DC that includes a federally qualified health center. Dr. Baker's work focuses on health equity research and policy, particularly for LGBTQI+ populations. And actually, I'm going to skip to Lawrence Deaton. Is also connected to Whitman Walker, as we'll hear about in a minute, is the Murdoch Head Professor of Medicine and Health Policy and Senior Associate Dean for Clinical Public Health at the GW School of Medicine and Health Science. Prior to joining GW, Dr. Deaton held regulatory research and policy leadership positions at several federal agencies for over 30 years, including as the founding director of the Center for Tobacco Products at the FDA, led HIV therapeutics development research at the National Institute of Allergy and Infectious Diseases, at NIH, and there's even more. But in addition to that, Dr. Deaton was a founder of the Whitman Walker Clinic. So the community-based, the community-based service organization for which Kellen Baker is the executive director of the Institute. Next, we have Courtney Jocelyn, who is a Martin Luther King Jr. Professor of Law at UC Davis School of Law. Professor Jocelyn is a leading expert on family and relationship recognition with a focus on same-sex and married couples. There's a lot more I could say beyond this brief bio. Courtney's also the reporter for the Uniform Parentage Act, which has been enacted in 7 states now. And then finally, we have Claire Coleman, who is the CEO of the National Family Planning and Reproductive Health Association, pronounced NIFRA. Okay. which represents about 1,000 nonprofits and government health departments that provide contraception and sexual health care primarily for people living with low incomes or without health insurance. So you can see we're broadening out beyond abortion access. And my first question for everyone is for everybody just to take 2 minutes as an introduction to the following question. Given the title of this panel and your work or your scholarship, what are your concerns about the impact of Dobbs? Start alphabetically.
Okay. Thank you so much, Naomi, for the introduction and everybody for joining us today. As you heard, my name is Kellen Baker, and I spend a lot of time thinking about the tentacles of Dobbs beyond abortion, because they really do extend everywhere. It's not just about the question of whether you can access a particular medical procedure. It's about who is empowered to make decisions for us about our bodies and about our health. And that extends to everything. In the work that I do, for instance, I do a lot of work with transgender and gender diverse people. At Whitman Walker, we have thousands of transgender patients. And something that's pretty critical for many transgender people is access to gender-affirming medical care. The first standards, expert standards, to guide the provision of gender-affirming care to transgender people were actually compiled in 1979. In the 1970s, there was a wave of court cases that talked about the rationale for why gender-affirming care is medically necessary and important for the health and well-being of transgender people, including cases in which, for example, a court looking at a Medi-Cal case said there's no reason that we could possibly fathom that this procedure, as a vaginoplasty for a transgender woman, would be considered cosmetic. It's so clearly medically necessary, it's so clearly part of the standard of care. In the 80s and 90s, we saw access to that care heavily politicized, with the idea that somebody who's not a transgender person knows better than a healthcare provider, knows better than a transgender person themselves, what kind of healthcare they should have access to. So we saw really a pretty desolate landscape of access to this care for many years, until actually the last decade or so, when a number of states and the federal government started removing these bans that were keeping people from accessing affirming care. Now, I am sad to say, we are going in the opposite direction. More than 330 bills have been filed in states across the country attacking the ability of transgender people to access medically necessary healthcare, attacking the right of LGBTQ people to even talk about themselves, who they are, what they need, what their families look like, and you'll hear more about that from Courtney. So when we're thinking about why this is happening, it's because we are accepting this idea that bodily autonomy is only for some. It is not everyone's place to make decisions about their own health, their own bodies, and what they need from a medical professional. And so again, not just abortion, but across the board, and in particular, you can see it very, very evident in these proposed bans on access to gender-affirming care for trans folks.
Perfect, thank you. Claire Coleman?
You surprised me there, Naomi. When I think about the impact beyond Dobbs, I think about the fact that for our contraceptive rights and access, these rights and access points date before the Roe v. Wade decision. So in 1965, the Griswold v. Connecticut decision was the decision that began to build out the notion that as Americans we had a right to privacy, and that right to privacy encompassed the right for married people to use contraception and get information about contraceptive methods. It wasn't until 1971 that unmarried persons also gained that right. And so when we think about how Dobbs is nested inside the right to privacy, among other rights, it is nested with the rights that were articulated in the Griswold decision. And so when I begin to think about how we should anticipate, we are seeing, we will experience the undermining of the legality and legitimacy of contraception, it goes back to this notion of what was first articulated or began to be built out in Griswold. Of course, people were using contraception ahead of the Supreme Court granting those rights, right? For time immemorial, people have found ways to inhibit conception. But in the context of this conference and surrounded by lots of lawyers and law students, I think about how Griswold is so deeply, deeply implicated, not just because Justice Thomas called us out, but how deeply, deeply implicated our rights are because of the nesting of Griswold and Dobbs.
Yeah, thank you. So just general high-level response to your question. You know, as state houses and courts criminalize the delivery of evidence-based standard medical care, we in the health professions and in health professions education have to wonder, you know, if abortion today, what's next? Obviously, contraception, treatment of fertility and infertility, treatment for gender disorders, providing just routine medical care for our patients who are transgender. You know, we've seen in the last 2 or 3 years, you know, issues around prevention and treatment of infectious diseases such as COVID, HIV infection, treatment of addiction disorders. These are all the tentacles. I love that concept, Helen, the tentacles of Dobbs. So how do we educate and train our clinicians to deliver the highest standards of evidence-based, medically consensus-approved care when actually providing that medical care might make those clinicians criminals? And then there's the direct injury to the patients that we are charged to care for. And then we also, I think, have to think about how are we going to mitigate the moral injury to physicians who are educated, trained, ready, and ethically obliged to deliver that care, but are not allowed to do so.
Okay, great. Well, thanks, and thanks so much to the organizers. Such a fantastic 2 days. And I guess just to start with a sort of very broad level question, what am I concerned about? I think very broadly speaking, what I'm concerned about is the way in which Dobbs has really emboldened those who seek to chip away at existing liberty and equality protections, very broadly speaking. And you know, we certainly see this in the abortion context. Things that I think many people thought were off the table even just a few years ago are very much on the table. Complete bans on abortion with no exceptions for situations where the life of the pregnant person is at risk, or laws criminalizing the behavior of the pregnant person themselves. These kinds of brazen attacks are not limited, though, to the abortion context. So we certainly see this happening in the LGBTQ context. And you know, here I'll just quote, there's a new report that was issued by the Movement Advancement Project, or MAP. And their words, to use their words, they describe anti-LGBTQ forces as launching fast, furious, and coordinated attacks that are astonishing in their breadth, cruelty, and flagrant disregard for personal freedoms. That certainly includes bans on gender-affirming care for trans people. It includes laws like Florida's Don't Say Gay law that is going to prevent, it does prevent the discussion of LGBT people and issues and families in schools. But there are also a range of maybe less visible types of attacks on LGBTQ people. So take non-discrimination protections. There certainly are efforts to repeal existing laws protecting LGBTQ people from discrimination, but we're seeing really novel and really insidious proposals on the table. One really brazen example is a bill that has been introduced in Florida that would statutorily treat accusations that someone engaged in in discrimination against LGBTQ people as defamation per se, with a statutory damage amount of $35,000, which is absolutely chilling. It will prevent people from raising concerns about experiencing discrimination in the workplace, in public accommodations. And obviously, if this law was enacted, it really would chill, again, people's ability to protect themselves from discrimination. And I think much of this, at least to me, and maybe I'm naive, seemed really unimaginable 5 years ago. I mean, it's just, we're living in such a different world. And so I guess, again, to kind of sum up, I'm just deeply, deeply concerned at the scope of the rights that are now at risk and how fast and furiously things seem to be moving.
This is a great preview some of the additional that were depressing preview, but good preview. Everything from bodily autonomy to access to contraception to the impact on transgender care to the impact on healthcare training for the future. So let me drill down a little bit on some of these themes and go back to Professor Jocelyn. As you've said, as both Claire Coleman and Dr. Deaton have said, in Dobbs, in overturning Roe, a 50-year-old substantive due process decision, at least on that basis, and also dealing with equal protection, how do you think about, in conjunction with some of the other important Supreme Court decisions that protect LGBTQ plus people, such as Obergefell and Lawrence? I mean, what do you think of, Justice Thomas expressly called these into question in his concurrence?
Yeah, yeah. So, I guess I'll start by saying, as we've heard over the last 2 days, even though the decision is a pretty recent vintage, it's already having really devastating consequences for women's health, for women's equality, particularly for low-income women, for women of color, and young women. Of course, I think, as we all know, at points in the opinion, Justice Alito tried to assure us that the horror stopped there, that other protected liberties, including marriage for same-sex couples established in Obergefell, protections for non-marital sexual intimacy protected in Lawrence, were safe, right? He wrote, "Nothing in this opinion should be understood to cast doubt on precedents that don't concern abortion." I think probably for many people in this room, they likely agree with the joint dissent, which did not buy this assurance. It seemed impossible. They explained to cabin the court's rationale to that context. To use the words of the joint dissent, the majority's assurance that its decision won't have effects on these associated substantive due process rights is like telling you that the Jenga tower is not going to fall over when they pull out the bottom stick. Is the joint dissent right? Will the court directly overrule those decisions? I think, certainly the joint dissent is right to be concerned. I agree with them that the rationale leaves those decisions extremely vulnerable. And, some believe that that's not just a bug, it's the feature, that actually is the intention of the rationale that was used in that decision. Reva Siegel, for example, has written that the deliberate goal of that theoretical approach was to cast a wide shadow on this long line of cases. So I think those risks are real, but I guess what I wanted to do actually is to linger on something that maybe is a little less obvious, which is to highlight something that's not just a possibility, but something that is happening right now, even while these decisions remain good law. And here I'm referring to a strategy that anti-LGBT activists have taken from the anti-abortion playbook, which is to urge courts to narrow the existing precedents while they remain good law. And I'll just share a few examples of the kinds of attacks that I'm talking about. So the two relate to marriage-based rights. One example is a case called Pigeon versus Turner, which maybe some folks know about. It's a case in which a number of private parties and Texas state officials argued that while Obergefell meant the state had to allow same-sex couples to marry, it didn't require government officials to accord same-sex spouses the same rights and benefits as different-sex spouses. And the specific right at issue in that case was employment-based spousal health insurance benefits. And I think probably, as everyone in this room knows, those benefits are so critically important to people's health and well-being and the health and well-being of their family members. And the denial of that right has very, very real and immediate impacts on people and their families. We're seeing similar kinds of arguments being made in the context of parentage. So there's another case, it's called In Re AE, also out of Texas, involving a child born to a married lesbian couple. Under clear Texas law, if she had been a man, it was absolutely clear that she would be considered a parent of that child. She consented to her wife's insemination. The child was born during the marriage. But in the case, the Texas appellate court held that the female spouse was not a parent of their child. And the reasoning should sound familiar. The court said, Obergefell simply mandated that Texas had to allow same-sex couples to marry. It did not, and here I'm quoting from the opinion, Obergefell did not hold that every state law related to the marital relationship or the parent-child relationship must be gender neutral. You know, there are cases going the other direction, holding that Obergefell does indeed mean that same-sex spouses must be accorded the same rights as other spouses. But these cases are not complete anomalies either. Some folks here might have heard there was a similar opinion issued out of Oklahoma last week. Oklahoma court held that a female spouse also was not a parent to a child born to her wife during the marriage, and indeed held that the sperm donor was a parent instead of the child. So I think these cases stand as really stark reminders that even if, in the maybe unlikely event that Obergefell is not overturned by the Supreme Court, that there are nonetheless constant attempts to limit what that decision means and the protections that it accords to LGBTQ families. And one final word, just kind of referencing some discussion from earlier panels, you know, it's not just in the marriage context too, right? In 2020, the US Supreme Court held that as a matter of statutory law, LGBTQ people are protected from workplace discrimination, and we're seeing similar efforts to sort of cut back on what that means for people. And one strategy that we're seeing is attempts to urge courts and legislators to carve out ever larger exceptions to these non-discrimination protections. And you know, as we've heard already today, the Supreme Court is poised this term to potentially create an enormous loophole to that protection, potentially to say that people have a First Amendment right not to be governed by these non-discrimination protections.
Thank you. There's certainly a lot going on in Texas.
Yeah.
Okay, I want to follow up, and I want to go to Dr. Baker next. In terms of sort of some of these aspects, Professor Jocelyn has set out some of the attacks that we're seeing on LGBTQ plus rights, and I want to turn it to you to talk about some of the parallels that you're seeing a bit between abortion rights and gender affirming care and the attacks on that. You started to talk a bit about that, but this gives you a chance to elaborate.
Yeah, thank you. And Claire, I really appreciate you going back to Griswold, not just because laying out the sort of hypocrisy of Justice Thomas's list, which is missing, of course, Loving versus Virginia. It's neither here nor there. But really, you know, what all of these efforts are about are not, again, about any particular medical service or any particular, you know, ability to be recognized in some kind of way before the law. It's about a concentrated effort to push people out of public life. The US started to change very rapidly around the time when contraception became more widely available, because people who could become pregnant, women, were joining the workforce. This has caused cascades of changes that have brought the US, I'm going to put my political bias out here, to a much better place than we were 50 years ago. And there is, of course, a very concerted political faction in this country that disagrees and really does want to rewind the clock. So again, it's not just about any particular healthcare service, it's about pushing groups of people, entire groups of people, women, other folks who can become pregnant, LGBTQ folks, to the margins of public life so that they do not have any political, social, legal, economic power. It is absolutely intentional, and it is quite coordinated. As Professor Jocelyn noted, there's a lot of parallels between what's happening in gender-affirming care, attacks on gender-affirming care, attacks on LGBT people. All of those activities that we're seeing on the front of banning gender-affirming care, for example, come directly from the anti-abortion playbook. Reliance on violence, intimidation, politically motivated bans. They have to be politically motivated because the medical science doesn't support banning abortion. It doesn't support banning gender-affirming care for adults or for minors. So we're seeing this effort to go and take every piece of what has been working, what has unfortunately been working to chip away at access to abortion and access to reproductive health services and reproductive justice more broadly, and applying that to everyone else that they can reach. And one of the things, sort of speaking about things that we're keeping an eye on and sort of very direct parallel, the Hyde Amendment, of course, continues to ban the use of federal funds for abortion, which disproportionately affects low-income women, of course, women and other folks who are pregnant on Medicaid, which has, of course, clear racial justice as well as economic justice implications. And we are seeing that language starting to circulate on the Hill for gender-affirming care. It's one-to-one. It's this worked here, so let's just keep going. Let's just keep pushing the envelope and see how far we can get, again, in this larger project of ensuring that only a very small handful of people who look like me, let's be real, although I'm transgender, which would, freak every, they can't quite deal with that. Only to make sure that only a certain handful of people in this country hold, again, economic, legal, social, political power. And so I think I'm very concerned about attacks on gender-affirming care, both because of what they do to trans people who can't access the medically necessary, life-saving healthcare they need, provided by licensed clinicians under the supervision of expert standards for more than 50 years in this country, but because of what it means about these broader questions of who should be able to be a person, who should be able to walk through the world, to access services, to make decisions about who they are and what they need, and how they engage in public and other types of civic life.
I should, just as a footnote to that, I've been looking at the deployment of parental rights rhetoric when it comes to minors' access to abortion, same parental rights rhetoric that you see with gender-affirming care, also with critical race theory. I mean, it's the playbook, as you pointed out, is the same. Okay, so we've started talking a little bit about some of the medical issues. Earlier panels talked about the medicalization of abortion, but at this point, we desperately need healthcare providers who are trained in abortion, who are trained in providing abortion. I should say that one of my first presentations post-Dobbs was a third-year resident at UVA, OBGYN, who said, what is going to happen to my medical training? I want to be an OBGYN who can do, who is trained to do abortions. So turning this to Dr. Deaton, can you talk about the impact of Dobbs on medical education, residency training, medical practice? And you're in DC,
Yeah.
right? So yeah,
Exactly.
talk about bubbles.
Yeah, so thank you. And this is a very important conference. And I really appreciate this last panel because, again, the concept Kellen has said about the tentacles of Dobbs is something that is really challenging all of us. Now, in medical education, as a medical educator, I want to talk about the impact of both Dobbs and those tentacles. First, I think as many of you are sort of following the post-Dobbs world in recent months, there's been a lot written about how the Dobbs decision has really complicated the ability of medical education and training programs in states where restrictions exist to meet certification requirements. That's what that resident was talking to you about. So, since the Dobbs decision, the accrediting body for medical specialties has explicitly reaffirmed that for every accredited program, regardless of where it's located in the country, the didactic and clinical training in evidence-based surgical and medical abortion is required for multiple specialties, OBGYN, family practice, et cetera. So that exists. And I looked up some numbers. There are currently 2,600 OBGYN residents being trained, 6,700 family medicine residents who are doing their residency training in states that have already have restrictions. 48% of medical students who are currently in medical school are getting their education in states with significant abortion restrictions. These physicians in training are at risk for insufficient or no clinical exposure to the evidence-based medical care and reproductive health. And for the residency training programs, they will be unable to meet the requirements for certification if they don't get that experience. So right now, our field is how the hell are we going to get experience for all of those OBGYN and family practitioners so that they can be certified? And is there even enough slots around the country if people want to go to a state where they can get that experience? So that's a current crisis. Make no mistake, the significant hidden impact of those limitations on medical education is that practicing physicians and physicians in training have gotten the clear message that legal considerations of health care, medical care, are being placed above scientifically established medical evidence and our current standards of medical ethics, which govern our profession. So speaking of ethics very quickly, I mean, there's really every aspect of medical ethics and the very basic tenets of how we practice medicine today are being violated by the concept that these kinds of legal considerations, be it for abortion or any of those tentacles of abortion, are being prioritized over scientifically established medical evidence. And that's the respect for patients, patient autonomy, beneficence, non-malfeasance, primacy of our patients' welfare, social justice, patient-centered care, evidence-based care, and health equity, all being violated. So if Dobbs allows criminalization then of selected medical practices, and again, if those tentacles begin to happen, then of course, that directly interferes with the basic tenets of how I practice medicine and how all of us licensed to practice medicine or nursing or PA or NP, it's the autonomy of our patients to seek and receive care for conditions for which there exists effective interventions that are scientifically proven and that we as providers of that care are obliged to provide to the extent of our abilities. So again, there's direct harm to our patients because they're unable to get the care that they need and want. And then there's that concept of moral injury to physicians and other providers who are restricted under penalty of law to deliver the care we're trained to give. And there's also in a way a moral injury to us who are educators because we're unable to prepare those clinicians in training to be the best physicians, nurse practitioners, PAs that science will allow. So of course, the concept, and we talked about this on a conference call before, planning for this, moral distress, moral injury happens when an individual believes they know the ethically appropriate course of action but can't carry it out. So to state the obvious, the impact of Dobbs on the medical profession and on education is creating moral injury for our clinicians and our clinicians in training. And we're all aware that this isn't limited to abortion. We've already begun talking about those tentacles. So, what additional legal decisions may restrict the delivery of that evidence-based medicine that a licensed clinician is able to provide to their patients? So as I said when we started, what's next? Is there soon going to be limitations on what I can do as a physician in terms of providing contraceptive care, treatments of infertility, treatments for gender disorders, treatment for just normal medical care for my transgender patients, treatment and prevention of infectious diseases like HIV, COVID, addiction disorders? These all are on the table attached to those tentacles. So we've already seen, we're talking today about some of those challenges, but they're all medical issues for which, as a medical educator, I am required to train the next generation of clinicians to provide that scientifically established care. My certification at the GW School of Medicine and Health Sciences is dependent upon, my certification to give MD degrees is contingent upon me giving that education. And yet we're putting our clinicians in conflict here, that moral injury concept. So what am I supposed to teach my students and my trainees, my interns, my residents?
Advocacy.
Unfortunately today, for medical education on standard medically accepted abortion care, and increasingly for treatment of gender disorders and normal care for transgender patients, I have to include in that education that legislators and courts are poor physicians, but they have the power to throw you in jail if you try to be a good one. This is not what I want to teach future physicians in this country or anywhere else. So the moral injury then that we're creating for clinicians on top of the professional burnout created by recent both indirect and direct threats to clinicians and healthcare providers caused by the rejection of science-based recommendations for COVID prevention will cause rejection, will cause an increased flight from the medical profession, is what my fear is, by those who are simply trying to help patients and help improve community health. And then when I think about those jurisdictions that today have restrictions for abortion care, and that, in fact, there's this big overlap of that geography with jurisdictions that were really violently opposed in some cases to public health interventions and prevention of COVID, and the impact on the practicing community, the medical practicing community, I think there's, at risk for great flight out of the medical and healthcare professions in those jurisdictions, worsening what already is some really basement level statistics on healthcare in that part of our country. So I'm sorry to end on such a pessimistic note, but that's where I am.
Thank you. As you were discussing how judges and legislators are poor medical decision makers, does everybody remember that the Alexandra Petrie piece, "Where is my mat?" she said, as I was getting an epidural. Where is the judge who's deciding the abortion medication decision to make my decision for me rather than my medical provider? Okay, one of the great things about this conference is bringing together researchers and service delivery people and people who see service delivery. I should mention that Claire Coleman was the CEO of Planned Parenthood for the Mid-Hudson Valley before coming to NIFRA. So the question, the question for you, you've already briefly talked about Griswold, but what are some of the issues that you're actually seeing in service delivery going beyond abortion access?
Well, the politics of abortion already pretty significantly impact contraceptive access. There are 17 states right now that put restrictions on the use of public funds for contraceptive services by those who also provide abortion care. And a state that, I can choose any number of them, but let's just talk about Iowa. When Iowa restricted abortion providers in the state from receiving government funds, public funds for contraception, the share of their patients that went without any contraceptive method shot up to 2/3. So the politics of abortion have visited very significantly on contraception well before Dobbs. Right now, as more states move to significantly restrict abortion or ban it entirely, those states are now in direct conflict with the Title X federal family planning requirements. So in Title X, when you see a patient with a positive pregnancy test, the visit is guided by their wishes and preferences. So if a patient says, "I'm thrilled," you don't say, "Let me walk you through your options," right? You are responding in the service delivery context to what the patient is telling you they want from the visit. We are, however, required to counsel and refer for abortion, again, at the request of the patient. So we have 12 states now, right, with either a total abortion ban or a gestational week ban. And just to use the federal family planning program again as context, of those states, we have a number of them that are a combination of a state abortion restriction, again, a full ban or a gestational week ban, and the recipient of the federal Title X dollars are the state government. So you've got a state government barring abortion and putting pressure on the systems then to neither counsel nor refer for a service that is significantly restricted or banned in the state, and an entity that signed a federal contract saying that it would adhere to the Title X rules, which are also the nationally recognized clinical standard. So Dr. Dayton talked about, how he's confused about how he delivers medical education. Providers are in conflict and confused about what they can and cannot do when it comes to options counseling and referral, given abortion bans in the state. We also have a situation right now in Texas where lots of terrible things are playing out, where clinicians are not providing federally funded family planning care without parental consent. We are awaiting the play out of a U.S. District Court decision, the DeAnda decision, and so the providers across the network in Texas are refraining from offering care without getting parental consent. And then the other thing I would mention that we are seeing quite a bit of, and we saw this also in the wake of the 2016 presidential election, so we've got a lot of patients coming in early for IUD removal and reinsertion. They want to restart that clock and get as much possible protection as they can. We're also seeing an uptick in the need and interest for vasectomy services, which is an atypical service, at least in a federally funded family planning context, but is something that we're seeing patients have a lot of interest in. I'll mention one other thing, being cognizant of time. Providers are really worried about patients losing trust in them, especially among folks that we are seeing who have historically had tons of reason to mistrust providers of care. And do not walk in with the lived understanding that they're going to be seen and heard and responded to. So every time we are in a situation where we feel like our ethical commitments, our personal commitments to meeting the needs of the people in front of us clash with a government restriction, we are also really cognizant that we're digging underneath any basis of trust that we might have established either individually with a patient or with a cohort of people who may historically have been treated very poorly in our healthcare system. And so we are, I think, in a cascade of crisis in the service delivery, and I really appreciate, Naomi, you mentioning that I did work out in the field. I think I am frustrated quite frequently with the sort of academic understanding of how this all works and what it actually is to run a health system and see 35,000 men, women, and teens in any given community. I think that experience is so important also to bring into the context of these conversations.
Thank you. This is great. I did want to ask one final question, but I'm instead going to turn it to the audience. So please do ask questions. But my final question, and I give this to somebody else to ask, is what gives you hope? Because we've been hearing about so much that's not supporting access to these services. And so we have to think about some things for hope. Okay, but if there's time, we will get to that.
I have a question for anybody who wants to answer. I assume that Claire, but maybe also others, concerning the threat to IUDs, to Plan B. FDA recently revised the labeling for Plan B to say that it had no effect on fertilization or implantation. IUDs, as I understand it, do have an effect on implantation, although please correct me if I'm wrong. And I am a historian as well as a lawyer and was looking at discussions about just oral contraceptives. And at least back in the 80s, there were opponents of oral contraceptives that said it could interfere with implantation and therefore oppose it on that level. So just all those concepts for you, and interested to know whether there's anything actually happening on the ground in any states to ban those forms of contraception.
Thanks for the question. Some of this was happening ahead of Dobbs, right? So really the conflation between abortion and contraception begins in the 90s with the approval of Plan B and then eventually with medication abortion. Anti-abortion advocates will say that abortion is embryonic death. So therefore, anything that prevents a fertilized egg from implantation is a method of abortion. Of course, ACOG has a definition of that, right? The legal definition of pregnancy is implantation. But they have, just pushed and pushed this notion that all IUDs and emergency contraception, as I would say in the Capitol Hill context, cross the line. They cross the line from contraception to abortion. And another thing to think about as a historian and as someone thinking about the broader context is that going back to Hobby Lobby in 2014, right, the belief that something was a method of abortion, even though it wasn't grounded in science, was considered enough to have a moral objection protected, a protected moral or religious objection. So ahead of Dobbs, states like Missouri were working to exclude certain contraceptive methods. We do anticipate that continuing. And I would just say, if you take the logic of Dobbs, you don't even actually have to attack contraception, right? You can start from Dobbs's rationale and say, if this is considered abortion, they are therefore excluded. And I think one of the concerns we have, the list is so long, but one of the concerns that we have, right, is that someone would make such a challenge and then there would be an appeal and perhaps a stay pending appeal, and it would go up to the Supreme Court, and the Supreme Court would just fail to act, which is what they did in SB 8, right? And they let something that is plainly in violation of Griswold stand. So yes, we are quite concerned. I have to say that so far, what we're seeing in state legislative cycles is more still an emphasis on driving the advantage on banning abortion and not yet, and we're in the beginning of legislative cycles, the total turn towards contraception. But we've got a cheat sheet, right, of what we think is up ahead for us, and that is certainly high on the list.
Yeah, and just really quickly in relation to that too, I'm sure many of us are watching yet another case in our favorite district, the Northern District of Texas, about medication abortion. That is also where a recent decision came out related to HIV, access to PrEP, pre-exposure prophylaxis for HIV. And just kind of going back to what Dr. Deaton was saying about the relationship between patients and providers and what this is doing to our ability not just to deal with any particular reproductive health need or even gender-affirming care, but everything where we require a relationship between a patient and a provider. It's COVID, getting vaccines, right? It's managing chronic diseases. It's staying on top of healthcare broadly throughout someone's lifespan. And thinking about, too, what we're seeing in the states in relation to the connections between all of these things is Tennessee, for example, refusing $8.3 million worth of federal money for combating HIV in one of the Trump administration's designated top 20 hotspots in the country because they don't want that money going to Planned Parenthood and they don't want it going to community groups that serve in any way LGBTQ people. So a little bit sort of stepped off of your immediate question, but I just think it's such a, we're definitely seeing all of these pieces knitted together in an agenda. Tentacles, yes.
Thank you. Thank you so much for being on the panel. I'm going to try to frame my question in something coherent because there's a lot of threads in my head. But, you're talking about misogyny and homophobia and transphobia, and I kind of wanted to complicate it a little bit and weave in classism and racism, which hasn't been explicitly stated because I agree with you all. I've been in some dark places in my head with pessimism and dystopia, and I can see that all the strands are becoming undone and anything is possible. I didn't think Trump was going to get elected, and now anything's possible. However, I see certain possibilities as less possible based on the classism and racism and the current power structures. So fertility treatments, for example, we've had frozen embryos for a long time, and the anti-abortion movement has left those untouched, literally in freezers, right, and metaphorically. And I feel similarly about contraception to some extent. I mean, I know it's being chipped away, but really for more lower income and or women of color, rather than returning to sort of this, I'm not a lawyer, but this pre-Griswold, where you can only use contraception like in marriage or whatever, because I think it would piss off too many middle upper class white women. And like even evangelical women use contraception. And so I was wondering if you could complicate your thoughts just a little bit with a little more intersectionality.
I suspect everyone's going to say something. I mean, I guess so I thank you for the question. I think it's incredibly important. And I guess I'll say too, just in reaction to Naomi's question that she was going to pose to us, I mean, I think one of the things that I find heartening is the bringing together of people across various kinds of silos. So, and having these kind of interdisciplinary conversations and conversations that bring together these different intersections. In terms of LGBT folks, which is a strand of my scholarship, I guess one thing that I wanted to flag that sometimes is not well understood is that LGBT people tend to be, contrary to myths and stereotypes about the community, are disproportionately likely actually to be poor and to be people of color. And so to the extent we have a perception that LGBT people are more affluent and white and therefore maybe then would be protected or more insulated from some of the attacks, it's important for us to be cognizant of the fact that the community actually is much more diverse and for that reason is maybe sort of, again, less insulated from some of the attacks that we're seeing.
Yeah, thank you for making that explicit. Talking about bodily autonomy, of course, in the context of the United States in particular, the original violation of bodily autonomy was slavery, which we still have not gotten over. As a country, we continue to endorse and perpetuate systems of structural racism that make it hard for particular groups of people, particularly Black and brown people, particularly folks who, for whatever reason, are deemed less than by the prevailing power structures, to be able to make personal decisions about their own bodies, their own lives, the resources that they need, their families, their communities. And so thinking about moving beyond Roe, I was having a very interesting conversation with a friend right before this panel where we were talking about, she made an excellent point about how in some ways, and I am paraphrasing, so in some ways it's good that we have to move beyond Roe, because Roe about abortion, fine. For many, many people, that's a really critical service. It also perpetuates a focus on a particular type of reproductive health service in a way that distracts from a broader lens of reproductive justice. It's not just about being able to get an abortion when we need one. It's about being able to have and safely parent the children that we do have, and to be able to be parts of our communities in ways that our autonomy as individuals and our role in our households, our families, our communities is actually respected. And so that maybe is a hope for me, that as we try to chart the future of where we are going after Roe, that we can actually move beyond this question of, well, is that specific service, abortion, legal? Yes or no? That's important, but it is really, really far from the most important question that so many communities are dealing with, and it is not the question that really takes into account the legacy and the continuing endurance of structural racism, of the ways in which access to so many things and so many rights, protections, autonomies in this country are rationed by income.
I would just associate myself with what Kellen just said and say, I think what you're seeing is the extraordinary power of white supremacy. Because for people of color in this country, they have been so driven to the margins and held there and held so strictly, so violently, that when I look around the programs that I work in and the people that I support, the patients that I represent indirectly and used to represent directly, they have already been driven beyond the limits of the law for years and years and years and years. And now we're in a situation where the poisonous fruit of white supremacy is going to be visited on a new cohort of people, because white supremacy has already taken its toll on people of color generation after generation after generation in America.
And I want to take your question of what, of what gives me hope, and a partial answer to this question too. So, in my scope of my world right now of a medical educator, I'm just really excited that I think it's 55% of people who are in medical education today are women. And that's such a major change from when I was educated. And I've been called a malignant optimist with the work that I've done in my life, and I feel very optimistic when I look at those people who are being educated to be future physicians. And Dobbs really, in a way, did something very positive. These young women who will be physicians are pissed off, and they are entering a profession that where they will have a degree of authority, power. Their voices will be heard, and I want to do everything I can to support that advocacy. And it's, Kellen, what you said before. We here at GW do teach advocacy in our medical school. We teach our clinicians that their role is at the bedside and in the clinic, and their role is in the community, and how to do that, and how to advocate for improved community health. And so one of the dominoes of Dobbs, one of the tentacles of Dobbs, is that the majority of people who are being educated to be physicians tomorrow are women, and they're pissed off, and they're going to do something about it.
On that note, a note of hope, but also a note of making sure that we are attentive to all of the intersectionalities as we think through these issues. Thank you to everyone on this panel for raising these intersectionalities, and thanks to all of you.
Thank you so much, and that was great, Naomi, to have us have a moment of hope here. Please join me at 4 o'clock for Dean Kim Mutcherson, who will offer the closing keynote speech. I'll explain why she's not here in person when you come back at 4 o'clock. Thank you.